This isn't your average day in court. What starts as a simple violation hearing quickly spirals into emotional breakdowns, heated rulings, and a judge who's had enough on one side. We've got a defendant begging for another chance, swearing on everything he loves. On the other, a judge dropping cold, hard facts, 19 missed tests, repeated violations, excuses that no longer hold up, and that's just the beginning. You'll see courtroom strategy, raw emotion, and even a live phone call to a GED program mid-hearing. It's a roller coaster of redemption, consequences, and tough love. Stick with us, because this one will make you question, when does sympathy end and accountability begin? And remember, everything you're about to hear is 100% real. Let's get into it.
Within that 7 or 8 but Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't.
19 missed tests. Let that number sink in. The judge isn't just being harsh. This is a legal pattern of non-compliance in court-monitored sobriety programs. Even one missed test can be a red flag. 19. That's almost a willful disregard. And listen to how the defense tries to delay with "let's wait till next week." But the judge shuts it down immediately. Why? Because at this point, delay equals denial. What would you do in this situation? Give him one more shot, or is this where the buck stops?
I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Oh, please.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for alcohol.
Right here, the tone shifts drastically. The defendant isn't just explaining, he's pleading, promising anything, swearing on everything. And if you're wondering why the judge still doesn't budge, here's the key: emotion doesn't erase evidence. It's heart-wrenching, sure, but in the eyes of the law, feelings don't outweigh 19 missed tests, tampered videos, and obstructed camera angles. You can see the courtroom energy tense up. This is no longer a negotiation, it's accountability time.
Come on, I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond for
Of course.
Oh my gosh. Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows.
And there it is, the gavel drop moment. Bond raised to $10,000. Why? Because when a defendant repeatedly violates probation terms, missed tests, obscured camera feeds, and even drug use, the court must respond with increased severity. Raising bond isn't just punishment, it's leverage. It's the system's way of saying, you can't keep gaming the rules without consequence. But here's the question, was the judge too harsh? Or is this the wake-up call this defendant desperately needs?
Okay, Ben. Okay. Great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not going to do that. I can't. But fine. Because fine. All right, 7502.
She sent me an email from
if anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it, and he also
You went the day before court.
And I also went before.
Judge, she's been going. She's been going before even the last court date, and we
Prove it.
I can take.
Just when the courtroom seemed locked into one traumatic arc, we shift gears entirely to another case, another defendant, another kind of struggle. This time, GED completion. But don't be fooled, this isn't a feel-good moment yet. The judge isn't impressed by vague claims or soft excuses. Why? Because when a case has 11 resets since May, talk is cheap. This next segment dives into a different kind of accountability, proving commitment with evidence, not emotion.
that class was canceled on the 4th yesterday. But she did, attempt to go to class. So she's been going. She did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
Now I'm trying to text you.
Texting who?
The instructor. Like, what I'm supposed to show you? Because I don't have no proof. Like, I don't have no.
You heard that right. While being grilled about court progress, the defendant appears to be texting. The judge catches it immediately, and boom, another credibility hit. Moments like these reveal just how much perception matters in the courtroom. Whether or not she was texting the instructor, the optics were awful. Be honest, if you were the judge, would you take this person seriously? Or would you see this as more of the same deflection and distraction?
You complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number, because I'd like to call them right now. Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So I've got him. Okay,
Hello?
Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a probation education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
How long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question. Depends on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I've worked with people that have gotten the GED in 2 years.
Oh, yeah. I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's been faithfully attending though. Yay or nay?
Yes.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay.
And just like that, the hearing winds down, but not without a powerful lesson in the end. The judge shows restraint, opting for another 30 days and a final chance to get that GED. This courtroom gave us it all: emotional outbursts, legal consequences, second chances, and raw human moments that blur the line between justice and compassion. Not so. What do you think? Was the judge too harsh or exactly what these defendants needed? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns. This is real justice, unfiltered and unforgettable.